But then let's say your H-1B is in March and April. You got to know what's going on. If you're chosen not for the most part, and your student visa is coming to an end in March. At least your OPT ends in March, or your F1 graduation is in March, or maybe it happens a little bit later before. There's an issue of cap gap that pops up because your student visa or your school may be ending, but your H-1B case may be pending. What does that mean? Can you stay here longer? Can you work while the case is pending? How does that work? And this is where the concept of cap gap comes into place. Could you get into that for our viewers, Anya, what cap gap is about?
Right. So not everyone is eligible for cap gap, not all the students. Okay. And there are certain requirements that have to be met in order for you to qualify for that. And again, there are certain separate concepts. There is H-1B lottery, right? And lottery registration and everything that comes with it. And there is the process of filing H-1B petition with USCIS. And those are two separate things.
Sure.
Okay, first that we're gonna have, as John mentioned, in March, when the lottery will be open and we'll know results by April. Okay, and after that, only those who were selected in the lottery, they will be able to proceed further with their H-1B petitions. Okay, and first thing, in order for you to qualify for cap gap, for cap gap exemption, right? Your employer actually has to file an H-1B petition on your behalf with USCIS. So participating in the lottery or submitting the registration or anything like that, it doesn't work like that. It's not a criteria, right? It's not. The first requirement is that the petition has to be filed. And what I mean by filing is that, again, USCIS has to receive it.
Yes,
and for those
I-129.
Yeah, and for those who don't know, USCIS does not follow so-called mailbox rule. So usually the deadline for H-1B petitions is June 30th. All right, but by this time, USCIS actually has to have your petition there. So the receipt notice of H-1B petition has to be issued not later than that.
Yeah.
Okay.
But when you file it, you have to be in status at the same time. You can't be out of status.
Yes, this is the next thing that I'm going to talk about. Sure. Right. So the petition has to be filed. Okay, and you have to be in valid status. And in this context, I would like to talk about two things. First thing is that you can be in valid F1 OPT status in your grace period, which are 60 days after the expiration, right? Or you can be still on OPT AAD, kind of thing. Okay, when you still have your work permit valid. So depending on when your employer files, it would affect your right to work and right to stay in the United States. Again, as I said, you have to file.
Yeah, that's interesting because when the I-129F goes in the system, I-129F goes in the system, and whatever your status is in that time, whether you're OPT and working or whether you're in your grace period, dramatically affects what you can do while the case is pending in the United States.
Correct. So if your employer filed in your 60 days grace period, you are authorized to stay in the United States, right, for this time, but you're not authorized to work because your work permit already expired by this time. And it doesn't get automatically extended by filing the petition. But if your employer filed the H-1B petition with USCIS while your OPT EAD was still valid, then you can stay in the United States and you can work. So both your status and work authorization automatically get extended.
Yeah, and so that's really important because the employer is the one who files the I-129 and they hire the lawyer to do that. You have to be mindful of when it ends because you want to be able to take advantage of cap gap and be able to work until the H-1B petition is approved. And the employer or the attorney may not be fully paying attention that's working on it. So you want to push them and say, listen, we got to get this I-129 in to take advantage from being able to have work authorization and not avoid getting in the grace period because that's going to be bad. Now, if you unfortunately OPT ends and your grace period ends, then you can't change status to H-1B. You could leave the United States and come back in with the H-1B visa once you're approved. But if you're trying to hold it over and continue working and be in the United States, not have to do that trip, this cap gap situation becomes really pivotal in helping you out.
Yes. So two additional very important things about qualifying for for cap gap. Is that on the I-129 petition, which is H-1B petition, there are special supplements filed with this and other things, but again, I will not go too deep in that. So you have to, your petitioner has to request change of status for you, because if your petitioner requests, for example, consular processing, it does not give you automatic extension.
Yeah.
Okay. Yes, and the employment start date have to be listed as October 1st too.
Yeah, it's automatic October 1st. It's a weird situation because the employer is the one who files the I-129, and the lawyers sometimes don't communicate directly with the applicant as much, the foreign national. They don't catch stuff. I've had people come to me where they have a J-1 visa subject to a 2-year requirement, which means they have to leave the US, wait 2 years, and come back in or request the waiver. And the attorney that's working on a case is working with the employer and not getting too many questions about the employee and catching the fact that they're subject to a 2-year requirement, which means that they won't be able to change status to H-1B or even get the H-1B without the requirement being waived. So to the extent possible, try to be active, communicate with the lawyer, and educate yourself. And that's what these videos are for, so you can protect yourself first and foremost, to avoid hassles that come up. And another hassle that could come up is the degree requirement. So obviously, the H-1B is about specialized knowledge. We'll go ahead before jumping into that, Anya. I'm sorry.
I just wanted to add one last thing about
go ahead.
Yeah. Sorry, I always have something to add. Yeah. So for the extension is automatic, the cap gap extension, as long as all this criteria met that I just mentioned, right? But there is no paper saying that you have this extension. So what you can do is you can ask your school, your designated school official, and they will insert this in the system, in the civic system, and they can issue a new DS form. And in this new DS form, they will be written that it's extended, and so on and so on and so on. So, and you can use it as a proof of your lawful status and the proof that you are still authorized to work, even with the expired EAD.
Is this the I-20 that the F1 students get?
Yes.
Oh, perfect. Okay. Cool. So
yeah, I'm sorry. I said DS-290. This is for J1.
That's right. Exactly. Yeah, it gets confusing because a lot of this stuff we're talking about, the grace period and stuff, the J visa holders apply to. We're gonna have probably a separate session because these J cultural exchange students, a lot of the time they're doing doctorate degrees and studying postdocs, so they actually are big users of the H-1B category. But it's just a lot going each one, so we'll make a unique video for that one. But with regard to student visa, obviously you're studied, you have a bachelor's degree most likely, and you're basing your application for H-1B based on having this education. Thank you for watching this educational program. To get the latest videos, click the subscribe button and the notification bell icon. Also, help us help the immigrant community by liking this video and sharing it with your family and friends. You can also find us on other social media sites like Instagram, Facebook, TikTok, LinkedIn, and Twitter, where you find the latest updates on immigration news, policy changes, and tips. Be safe and God bless. See you soon.